hope will bring comfort to a grieving 9-year-old girl in Dallas. And God willing, propel her to move forward and dream and soar and make her daddy proud. We must make the most of our moment to fight for freedom, to protect our God-given rights, even of those with whom we don't agree, so that when we are old and gray, and when our work is done,
I mean, seriously, can you all focus on the message? I couldn't. All I could focus on was the booing and the catcalling. We will get your calls in here on this and what you think the impact, not only on the race for the White House this time around, but on the political future of Ted Cruz. Coming up on the Chris Salcedo Show. In the meantime, there's something else you have to know about what has happened at the Fifth Circuit Court of Appeals and what didn't happen at the Fifth Circuit Court of Appeals. Let's bring in Byron Henry. He is, of course, one of our legal eagles here on the Chris Salcedo Show, appellate law expert with the law firm Scheef Stone, right here in North Texas in Dallas. Sir, welcome back to the Salcedo Show.
I'm glad to be here, Chris.
I heard the headline yesterday that the federal appeals court struck down the voter ID law in Texas, which was a complete inaccuracy. And I think Fox News got it right when they said federal appeals court orders changes to Texas voter ID law. Was I reading it right?
You are reading it correct. The Texas voter ID law was not, in fact, struck down. The Texas voter ID law was upheld for over 90% of the voting age public in the state of Texas. The only requirement that the court has put on the lower court is to reweigh some evidence about discriminatory intent, which will be taken care of at trial later. Has nothing to do with the election. They reversed the lower court on that issue. But with respect to the effect the law has on minority voters, the court determined that there are not enough alternatives, basically, that the law itself still places too much of a burden or makes it too difficult for a significant number, though the number is very low, both in numbers and percentage of eligible voters. It was still a significant number in the court's opinion that the court needs to fashion a remedy that allows these people a more convenient way to vote. In other words,
wait a minute. My understanding is that in Texas there is there are an equal number of whites who don't have voter IDs, lower income, I'm assuming, to those of black Hispanics who don't have voter IDs. So did the Fifth Circuit say that it was discriminatory against those white people who don't have voter IDs too?
No, even though the numbers were almost identical. In fact, there were about 600,000 voters that lacked the requisite ID. According, of course, we're buying the expert testimony of the, quote, voter advocate. So
right.
Let's assume those numbers are correct, that there are 600,000 voting age adults that do not have IDs. About 300,000 are white, and about 300,000 are black and Hispanic. So about an equal number. But the court focused on the fact that it is a higher percentage of the Hispanic and black voters that lack the IDs.
Okay, wait, hold on. Did the Fifth Circuit Court of Appeals just basically say that it's impossible to discriminate against white people? Because it's what it sounds like to me.
Well, unfortunately here, the court is looking only at the Voter Rights Act, not the Constitution, which, as we know, is supposed to be colorblind based on race. And the Voting Rights Act was specifically enacted to protect the voting rights of minorities, especially black voters. So the court focuses on the disproportionate percentage of black voters that lack the ID. But the interesting thing is the reason why they lack the ID. It's not that they lack the ID, the court said. The court says they lack the ID because of basically conditions and discrimination that Texas has created itself from its past. So it basically lays the blame at the legislature's feet in 2016 for things this legislature, of course, could not have controlled 10, 15, 20, 30, 40, 50, 60 years ago.
Whoa, wait a minute. Whoa. 30, 40, 50, 60 years ago, the Democrats ran things here in Texas.
Well, interestingly, the dissent pointed that out. She said it doesn't really matter which party you're talking about, but it was odd for the majority to hang prior actions by the legislature when it was controlled by Democrats and lay those trespasses at the feet of a Republican-controlled legislature in 2011, and the dissent took the majority to task and found it kind of bizarre to blame the 2011 legislature for things that happened 30 or 40 years ago under Democratic control. But nevertheless, the law stays in place. The state needs to negotiate, according to the opinion, with the plaintiffs in the case and come up with an alternative for the small, very small, single-digit percentage of voters in this state, I assume whites as well, though the court doesn't say, all voters that do not have the requisite ID and cannot obtain them, they need to have a way to cast a ballot. And that is basically that.
Wait, okay. By the way, Byron Henry is my guest right now. He is the appellate law expert with the law firm Scheef and Stone here in Dallas. Did the high court specify? Because if you're going to sit there and say that a law discriminates, isn't it incumbent upon the high court to say precisely how it discriminates? And I don't know how you discriminate against a person of color, a minority, a Hispanic, or a black, by saying that they can't obtain something that is provided for free birth certificates, right? Free voter IDs. If you get that free voters that certificate, and you got 2 years to get it. I fail to see the practical application of discriminatory practices here.
Well, it's both judicial activism and bad laws run amok. So it's a combination of judges looking for a result, as well as the law is so broad that says that if a law regarding voting creates a discriminatory effect, meaning you could pass the most homogenous, race-neutral, common-sense law in the history of government, and if after you passed it you did some research and said, you know what, fewer African Americans voted as a result of this law, according to this opinion, that would be evidence that the law was discriminatory because of the way it worked out in practice. And that's exactly what happened here, even though the dissent points out, and the majority does not dispute this, that there have been literally a handful at most of people that have not been able to vote in the over half dozen elections that have taken place while this law was in effect. So it is not denied anyone, according to either opinion. Neither one points out any situation where anyone was denied the right to vote. In fact, we've conducted 6 elections without incident under this law.
And not only that, voter turnout has increased under this law. I mean, it's absolutely insanity. But Byron Henry, I could probably talk to you the entire show about this whole thing. Appellate law expert with the law firm Scheef and Stone right here in Dallas. Always appreciate your legal expertise. And I'm assuming that they're going to go back to the drawing board and try to find some accommodation for this election cycle, correct?
That's correct. The state and the plaintiffs in the case will get together and try to fashion a remedy for this small percentage of voters that can't get a state-issued ID to vote in this November election. And then the case will continue and it'll work its way up to the Supreme Court, unless the Attorney General decides it's an important enough issue to take up immediately on an emergency basis right now, which remains to be seen.
Gotcha. All right. And, well, we're going to have you here to help us sort through it. Thank you very much. Byron Henry, everybody, here on the Chris Salcedo Show. 800-288-WBAP, 800-288-9227. The board is full of calls, and your calls are next. News Talk 820, WBAP.